Most people think that if they didn't have any intent to hurt anybody, then a car accident can't be a crime. But it's different here in New Jersey. Check out this video.
Police say a driver was speeding when she crashed into another car, which then led a third vehicle to be hit. 3 people had to be taken to the hospital, including a 6-year-old girl. SAPD says the woman and child in that first car were not wearing seatbelts when that crash happened.
After a serious crash, people are already dealing with shock, confusion, insurance, and police. And then they learn they're being investigated or charged with something called assault by auto. But how can a car accident with no intent result in a criminal charge? I mean, you just made a mistake, right? You can't be charged criminally for that. Yes, you can. Over the next few minutes, I'm going to explain what assault by auto actually means under New Jersey law and how it's different from a typical traffic offense and what factors determine whether a crash becomes a criminal case. My name is Daniel Rosenberg and I represent individuals who are dealing with criminal charges after a result of a car accident when they never in their wildest dreams imagined that they would be in that situation. So one of the biggest misconceptions people have is that if there wasn't any intent to hurt somebody, that you can't be charged with a crime. Most drivers believe it was an accident. I didn't have any intent to hurt anybody. There weren't any drugs or alcohol. This should just be a traffic ticket. But New Jersey law looks beyond your intent. Assault by auto cases focus on the driver's actions, the operation of the motor vehicle, and whether their conduct was reckless. So investigators and police are going to evaluate the speed, whether or not you were distracted, road conditions, traffic violations, whether or not you were on your phone, whether or not you were talking to somebody, whether or not you were listening to Spotify. The issue becomes whether the conduct, not intent, caused the injury and the level of injury. And this is a legal determination, not an emotional one. When authorities review a crash for potential assault by auto charges, they're generally asking, was there an injury? What was happening in the moments before the collision? Did the driving behavior rise above simple negligence, and was it reckless? And if your conduct is viewed as reckless rather than just simple negligence, now you're getting criminally charged. And so what's the criminal charge that you're facing? Well, these cases are highly fact sensitive, so it's going to depend specifically on your situation. First, investigators are going to look at physical evidence, accident reports, roadway data, timing, video, roadway cameras. Then they're going to talk to witnesses. Are there any observations? Did anyone see what happened? Can they describe it? Does anyone have it on their cell phone? And then they're going to determine whether or not this conduct and the proofs meet the legal definition of recklessness under New Jersey law. And so assault by auto is not about intent. It is about what the conduct is leading up to the incident and the injury. And drugs and alcohol play a significant factor in this analysis. If you're under the influence, now you're being charged with a crime of the second degree. But let's say that you're not under the influence, or at least you think you're not, but you took prescribed medication the day before. You smoked or ingested marijuana the day before. You drank the day or night before, and there's still remnants in your system. The state is going to use that to level higher charges against you. The higher the charge, the more control and leverage they have over you. Do you see how this works? And God forbid someone dies. If there's drugs and alcohol in your system, they're going to charge you with a first-degree crime of aggravated manslaughter, where you're looking at between 10 and 30 years in prison. So if you're involved in a motor vehicle accident where there's significant injury, you should speak to an attorney before you're speaking to law enforcement. There is no legal requirement when you're at the side of the road that you have to provide your version of events. And if you provide your version and you're wrong, or you have a concussion, or you misspoke, that's your version. So intent doesn't matter, your conduct and the resulting injuries do. If you're on the phone, texting, listening to music, if there's anything in your hand or if there's anything that's distracting you, that's going to be held against you. These charges are serious and significant, and they can and will alter your life. So if you or someone you know has questions about a motor vehicle accident, please contact our office. We'll take the time we need to evaluate your situation and give you the help and guidance you need. We are criminal trial attorneys. We have your back. That's what we do.